If you think Georgia's so-called religious liberty bill is straight up tripping, historically speaking, you're correct. On Monday, Georgia Governor Nathan Deal announced his plan to veto House Bill 757, titled the Free Exercise Protection Act. If passed, it would allow private individuals, businesses, and nonprofit organizations to deny services to customers on the basis of religious principle, or, in the words of the proposed legislation, to, quote, protect against infringement of religious freedom. Now, while the LGBTQ community wasn't explicitly cited in the bill's language, these types of religious freedom acts, or RFRAs, have historically been used to restrict services they could otherwise freely access. But here's the twist. While Georgia's RFRA is overwhelmingly supported by conservative Christians, its legal precedent has nothing to do with Jesus. That's right, RFRAs all trace back to the 1990 U.S. Supreme Court case, Employment Division, Department of Human Resources of Oregon versus Smith. Native Americans Alfred Smith and Galen Black were fired from a private drug rehabilitation facility after their employer discovered that they had ingested peyote as part of a religious ceremony in the Native American church they attended. Smith and Black were then subsequently denied unemployment benefits since their firing was attributed to misconduct. Smith then sued the state for violating his First Amendment rights to religion and speech. In 1990, the case arrived at the Supreme Court for the second time, and SCOTUS ruled in favor of Oregon's state government. Writing the majority court opinion, Justice Antonin Scalia presented a slippery slope argument. If such religious exemptions are upheld, it would, quote, open the prospect of constitutionality required exemptions from civil obligation of almost every conceivable kind. End quote. Scalia further hypothesized that if the court sided with the Native American plaintiff, then it might open the door for folks to skirt all sorts of legalities on the basis of religion, such as paying taxes, caring for children, getting vaccinated, etc. Disagreeing with the High Court's verdict, the U.S. Congress passed the Religious Freedom Restoration Act of 1993, barring state and federal governments from, quote, substantially burdening a person's exercise of religion. And then immediately upon signing the bill, a crew of U.S. senators hightailed it out of the Capitol building to a peyote ceremony. Just kidding. We think. Now, Georgia isn't the only state to jump on the RFRA bandwagon ever since. As of 2015, 20 U.S. states have passed various RFRAs. And for now, the jury is out on whether the Georgia GOP will overturn the governor's veto, upping that number to 21. But what do you think? Are these laws necessary or discriminatory? Get in touch and let us know. And to learn more about the stories behind today's headlines, visit now.howstuffworks.com every day.